Thank you, everyone. Please be seated. We are here this afternoon for the submission of four cases. The case of State versus Demetrius Martin is hereby submitted without oral argument. The case of Iowa Supreme Court Attorney Disciplinary Board versus David Leitner is also submitted without oral argument. The case of Iowa Supreme Court Attorney Disciplinary Board versus Mike Mabanza is also submitted without oral argument. Our first oral argument this afternoon is State versus Krogmann. It looks like parties are ready to go. Ms. Trout?
Thank you, Your Honor. May it please the court, counsel. The best evidence rule does not apply in this case. Following the defendant's arrest for attempted murder of his girlfriend, Jean Smith, DCI Special Agent Jack Liao conducted an interview with the defendant. That interview happened to be videotaped. At the trial, the state sought to introduce evidence related to that interview through the testimony of Agent Liao. The state did not seek to play that interview tape, but relied on the testimony from the agent who participated, indeed conducted that interview. Now, the defendant alleged that the court should have allowed him to play the entire video because the state allegedly opened the door to a discrepancy with whether or not the defendant could answer certain questions posed by the agent. The defendant wanted this and filed a pretrial motion in limine. There was some discussion, but ultimately the court determined that playing the 59-minute and 35-second video was not appropriate, and also mainly because it was hearsay. Following the testimony of Agent Liao, the defendant again wanted and made an offer of proof trying to get the court to admit this as the best evidence. Well, the Court of Appeals bought what the defendant was selling, indeed finding rather than keeping the best evidence rule or limiting it.
I think you're right about the best evidence rule, okay? Where I have trouble is on your hearsay argument. I tend to agree with the Court of Appeals assessment after watching the video that there's nothing he says about what had happened just previously that really is exculpatory. He admits to the shooting. He admits to getting a gun and shooting her. It's not exculpatory. But it's also, but at the same time, it is somewhat probative of his mental state, which was put at issue by the diminished responsibility defense. So why not? Why shouldn't it have come in?
Your Honor, the district court made the determination that it was hearsay, and admittedly, when you look at a 59-minute videotape, there are certain statements that are not hearsay. Indeed, the defendant's questions relative to how Ms. Smith was doing, it's a question, not a statement. There are the Miranda warnings, but then there are also statements that I loved her. I wanted to marry her. She should have to the defense. Well, it still is a statement. How is it helpful to the defense? I'm not under.
Was it offered for the truth of the matter, or was it offered for something else?
I think it was offered for to show the jury that this person who allegedly cared for her would not have been able to commit the act of shooting her multiple times. That it tries to portray this defendant in a favorable light, and as the state submits, perhaps lead to.
Video makes the defendant come off in a favorable light.
I think, Your Honor, that the video could curry some favor. It might evoke some sympathy. If a jury looked at it, they might feel sorry for this man. His
mental or his ability to form specific intent?
It was relevant to the extent that the experts were able to use that and to rely on it. I don't think that when you consider that this happened, admittedly, shortly after the incident, but what is more probative of his intent are the comments that he made to the victim during the course of the crime, where he said, "It's taking you a long time to die." And he shot her, and he refused. Those statements, yes.
It's weird that the state didn't want that video in, because almost always the trials I've seen or participated in, if there's especially the unknown factor of whether or not the defendant will testify, oftentimes, if not almost always, they're going to put an interview in, and the jury is going to get to watch it. So don't you think it's kind of unusual in that respect? And then secondly, is it just because the state was ticked off because they didn't get to cross-examine? I mean, for 59 minutes, about an hour, that guy's talking. So I'm just kind of trying to figure out, is there really any damage to it, or just sore feeling for not being able to cross?
The statements that he made to Ms. Smith did not come in by virtue of the videotape. He did make statements that he shot her. That is true. But
He says, "I did a terrible thing." I mean, how is this helpful?
helpful to the defendant? Your Honor, again, I just don't believe that the having the defense proffer a particular reason for wanting this evidence in you have to look at other reasons. And I think that
No. I mean, I think you would be the first to admit that the prosecution frequently uses evidence for non-hearsay purposes because they're interested in getting it in front of a jury. We can solve that problem with limiting instructions. It seems to me that this is content independent, right? I mean, they want to show his demeanor. It doesn't matter what he said. He could have been babbling. He could have been twiddling his thumbs. He could have been saying, "I love her." The point is that the way he conducted himself communicated something. So whatever he said, I don't see how that's offered for the truth of the matter asserted.
we will have to disagree with that. I think that when you look at what the defense wanted, so what the district court had to consider was the defendant's request to have 59 minutes and 35 seconds. There was no backing down from that. It appears both in the motion in limine, it also appears at the offer of proof. So 59 minutes goes on, and there wasn't any suggestion by the part of the defense that, well, maybe we can play a few parts of this or little snippets. Wasn't any of that. It was all or nothing. They needed to play all of it to demonstrate his intent. And when you talk about a limiting instruction, query, what is that limiting instruction going to look like in this particular case? You can, hey jury, you can consider this at this particular time for this purpose. You can consider this for this time.
District court judges do it all the time. This evidence is being offered not for the truth of the matter asserted, but to show evidence of his demeanor. Right? I mean, that's pretty easy.
That would be a one-size-fits-all, and even this court in Elliott had found that limiting instructions it's not a one-size-fit-all fix to certain cases, and the state submits that this is one of those instances. But even if you were to find that this tape should have been played for the jury, the error is harmless. The Court of Appeals got it wrong in finding that this went to the heart of his defense. Well, so did the testimony from his expert. So did the cross-examination of Agent Liao by defense counsel. And so did the testimony from his family members who said they were concerned about him. They removed the guns from his home. When you consider that, in addition to the statements that he made to Gene Smith about, I'm not going to call 911 because I don't want to spend the rest of my life in jail. The comment that, we're both going to die today.
It makes your argument circular if it's so dang harmless.
The nature of harmless error, though. We can argue one thing relative to the merits and then say, okay, the fallback position is, but it was harmless.
Then that would suggest that Krogmann and his counsel were not offering it for the truth of the matter asserted, but to show his demeanor, right?
Again, the state isn't buying what the defendant is selling. In that case, so now I think you're going to fall down a slippery slope by saying, oh, well, if we offer these, if now defendants can say, well, I didn't offer this for the truth of the matter asserted, I offered it for this purpose. Where does that begin and where does that end? I think it's a very, very dangerous position for the court to take.
Julie, when was this brought up? Was it a motion in limine? Was it a pretrial motion? Close the state's case? When was it? At what juncture?
Admission of the exhibit, yes. It started out pretrial with the motion in limine, and it was not, the court denied it, subject to something else happening. Then, after the agent testified, the defense made an offer of proof, and the court again denied that. And I believe there was also the motion for new trial, but the state submits that the motion for new trial would have been too late to preserve anything.
Argument is that it's already in this record based upon the testimony of the expert and Agent Liao. But isn't it most probative to have an actual video? Instead of someone talking about it, the jury can actually see.
Back to the best evidence rule, and what I believe the defense has conflated what is basically a rule regarding the authenticity of a document, a writing, or video. And it
go to the harmlessness of it, because if it is the most probative evidence of this fact and we have other people testifying about it, doesn't it need to come in?
Your Honor, we disagree with that. I don't think that simply because it exists that it needs to be played. We have testimony through Agent Liao. We have cross-examination of Agent Liao that would testify to that. And we have our state's experts that they...
Did the agent's testimony about what happened and what was said and what was done in that interview differ from the defendant's expert review of that same evidence? Or were they consistent?
They weren't necessarily inconsistent. It was the questions posed to Agent Liao were he thought that Krogmann was able to follow and track these questions.
Or thought differently?
Well, the defense expert thought that perhaps there were certain parts that he could understand or that he couldn't. But
and let the jury see what both of those witnesses have seen. Why is that not at least probative to allow the jury to make that decision when they're deciding who to believe between those two witnesses?
Well, Your Honor, I think that the state's position is that the video was inadmissible. We believed it to be hearsay, and that in a situation like that, what is done, what should be done, is that you have your experts rely on that so that the inadmissible evidence doesn't get in front of the jury. So that's exactly what had happened.
Hearsay, and that was wrong. Why should he not get a new trial?
Because, Your Honor, the error is harmless. That if we're looking...
Why is it harmless if it's probative to the defense he was trying to raise and it was kept out erroneously under the erroneous assumption that it was hearsay?
I think that when you have the testimony relative to what how a person is able to form intent and how what conscious actions, I believe Dr. Dennert had testified to that would be indicative of a person's intent. So when you look at what his statements were to the victim, you look at the plan that he hatched in order to do it. He did kind of a farewell tour to his family saying goodbye.
See, this is the thing that's kind of baffling. That's stuff where the jury ought to be able, it would seem to me if I was a juror, I'd want to see him and what he was like and not have experts talk to me in a bunch of, expert talk, because what's most going to be most probative is how he appeared to me.
Yes, Your Honor. And he didn't testify. So he escapes cross-examination by the state.
13 years later, and I mean, you have a video that has nothing exculpatory on it, as far as I could tell. I think the Court of Appeals said that you were stumped when they asked you to find something that was exculpatory on it, but that had a lot of evidence of his condition. What I don't understand is why the state continues to argue that it's somehow hearsay.
That's what the record that we were left with, and that's what I believe, that the court believed it to be hearsay, that there were all of these statements that were coming in that perhaps were not, maybe they weren't, maybe this court deems them not relevant, but the Court of Appeal, excuse me, the district court did. And so what we have is that we believe the district court was correct in denying the request for the admission of that exhibit, and also that if in fact the court did err, that it is harmless given the strength of the state's case. Thank you.
Ms. Campbell.
May it please the court, counsel. Angela Campbell for Robert Krogmann. It's our position that the Court of Appeals got this analysis correct as it pertains to the hearsay question and as it pertains to the best evidence rule. I don't think you need to reach the best evidence rule question, however, because it is answered by the hearsay question. The best evidence only really comes in if it is considered hearsay, because then we're dealing with a scenario where they've offered testimony about the interview, and then we're saying, okay, well, because you did that, the best evidence is the actual interview. If it's not hearsay, then it's not hearsay and it should have been admissible. It's clearly relevant. It is, in fact, in our opinion, the most relevant piece of evidence that you could possibly have in a diminished capacity defense trial. It is a video of the defendant in a restraint chair being asked questions. And
to be honest, that's why I mean, trying to figure out what was in the mind of the state and why they opposed the admission of the video, I think that's the most beneficial thing in the video, is the fact that the sheriff's office thought Krogmann was maybe unstable enough that he had to be strapped with his arms and legs into a chair. And so if you're a juror, you might look at that and say, well, if the sheriff's office thought he was in that condition, maybe he wasn't in possession of his faculties. But I don't know that that's really relevant. That doesn't really go to his condition. What goes to his condition is what he was like in his statements and in his demeanor. Help me on that.
that's the real reason the state didn't want it offered. They just don't want to say that.
59 minutes of your client talking and the state never getting to say, love? You call that love? I mean, I can just imagine a prosecutor. So 59 minutes. Tell me why it was all or none. That seems a little bit of overkill.
I don't know that it necessarily had to be all or none, but there was no specific objection to any specific statement. We cut off the objectionable part at the end where he's talking to an attorney. So we cut off that and offered it without that section. There was never an offer or an objection to a specific statement. We offered it all because it showed the entire interaction, bad or good, to show her the entire demeanor. We didn't want there to be some argument that we were manipulating the evidence. This is what the expert saw, and this is what the expert based her opinion on. Let him see it all. He admits to killing her. He actually admits to worse than what he actually does, because he's sort of led into that, admitting he goes back to the truck and gets a gun, and none of that was true. And so there was never a statement that we wanted in. So there also wasn't a statement we were trying to get out. We didn't care about the statements. We wanted them to see him in that entire video.
I'm imagining if I were the prosecutor in that case and I could see the dogfight was over and it was pre-trial, that's why I asked when did it happen, I'd probably say, fine, I'm putting it in. It's going to be on my terms, and I'm going to lay the foundation for it and make it look like you have to defend. So somebody could have done it differently. But in this situation, so then what's to stop you from just getting anybody and everybody out there? Any situation where he has talked, or get him to do a phone video of him talking about crap and that shows his personality or whatever it may be you want to show. Where does it end? You talk about a slippery slope. That 59 minutes, you say you chopped off a bit, but 59 is a long time for a jury to get to sit and watch your client untouched by the prosecutor.
It's 59 minutes, and it's a 35-year sentence. I would say it's a very short time for a trial. It's a 6-day trial.
Video for a jury, that's a long time.
Proffering a defense. He's not saying I didn't do it. He's not putting out other suspects. He's not putting out any defense. He's not actually even talking for the 59 minutes. He's like writhing around. He's sweating. He's rolling. He's barely answering the detective's questions. It's not a dialogue of him talking for 59 minutes. It's a video of his behavior for 59 minutes.
Should have tried to make hay with it themselves, but they didn't. And for whatever reasons, strategy or whatever it may be, they didn't want it in. And your reasons for getting in, I'm just asking, how is that going to be any different than we start seeing, everybody's got a phone with videos on it. Let's just start getting some videos. Hey, get your client to talk about it to somebody. Take a video of him yakking about it. I'm going to see if I can get it in and not have to put him on the stand.
You're talking about a diminished responsibility defense where you have an expert,
Lots of people.
but not right after the offense. So this is a video of him right after the offense. So a year later, not relevant. 10 years later, not as relevant, right? But this is the day of. He's still suffering from the episode.
The point of harmless error, because, I'm sure you're going to disagree, but my impression, after watching the video, given that what you want to show is that he lacked the capacity to form the intent to kill J.S. Well, he's. I think Agent Liao's description is fairly accurate. He's tracking. He is talking about going to get a gun in the truck. He's talking about shooting. He's talking about doing a terrible thing. It seems to me it's more he's ashamed of himself than he didn't realize what he did or didn't understand what he did. Am I misreading the video?
Yes, so what the expert would tell you is that the video is 3 hours after the incident. And so when you have these episodes, an episodic scenario where someone lacks the capacity for a period of time, they can regain capacity. And so, but that's a process. So it's not a situation where someone claimed, I lack the capacity, and then 3 hours later is presenting with no symptoms. He still is presenting with all the symptoms you would expect of someone who is coming out of one of those episodes. He's looking away, he's sweating, I would disagree that he's tracking. He's telling things that aren't accurate. You can actually tell when you know the case and you know that he has this sort of fog that is going on, that he doesn't know the answers sometimes to some of the questions. That's exactly what they're looking for because they've interviewed the defendant and he's expressed that to the experts.
Videos, a guy in the backseat of the car right after he shot and killed a woman, and they've, of course, got the cameras rolling, and he hears he's going to be taken to the jail, and he says, is there going to be cameras? Does anybody have a comb? Anybody have a comb? I mean, look what just happened. What happened was incredibly traumatic. So I guess I'm not persuaded that behavior in and of itself is indicative of what you're trying to argue.
We needed the expert to explain the behavior, to show the video and show this is a symptom. This is why I thought this video supported my diminished capacity defense. They can cross her on that and say, well, he's saying this here. Why doesn't that change your opinion? And she would have to answer that. But it is a video of the defendant who has raised a mental health defense as close to the incident as we possibly can have. The only other video we have of him is as he's getting arrested, where there's no demonstration of anything, no talking, no sweating, no anything. And so if you look at it from the question of harmless error, not as to whether he shot her, there was no question that he shot her. He said he shot her on the 911 call. The question is, what was his mental state at the time of the offense? And this video is the most relevant. Sure.
So I think in our case law, there's sometimes loose language about the standard that's to be applied to these kinds of errors. And maybe was there prejudice, however that's defined, harmless error, and sometimes we look at it as overwhelming evidence of guilt. And sometimes, most frequently in constitutional cases, but not always, we talk about, did the error contribute to the jury's verdict? So what is your view on the right standard? Because this seems like a case where that might matter. You know, if the standard is just, was there overwhelming evidence of guilt? Well, maybe. If it's something different, like did this lead to, or in any way affect the jury's verdict, maybe that's a different issue. So what are your thoughts on that?
Actually look at all the terms and they come to the same conclusion, and that is if the evidence could have affected the verdict, then it can't be harmless. And so I think you can take each of those phrases that you used and it means the same thing. And what I think happens though is we conflate the relevance of the evidence to the point it was trying to prove with the facts that the state presents as being uncontested. That's what's happening here. They're saying it's harmless because he shot her. It's not harmless error. And if the only question was whether he shot her, then yeah, it would be cumulative and it would be harmless. The question here is his mental state.
To be fair, I think the state says it's harmless, not because he shot her, but because he had a plan and he went out and he kind of contacted other people. He made multiple statements to her about that she was going to die, et cetera. So, I mean, there's more there. I mean, I get your point, but I mean, is that the calculus? Do we just weigh the evidence? And if we conclude that there's overwhelming evidence of guilt, then it's non-prejudicial, or is it something different?
Whether a reasonable jury could have come to a different conclusion.
And that might be the standard, but you would agree we have one standard for constitutional error and one for non-constitutional, and you would agree this is non-constitutional harmless error, correct?
Not necessarily. It's raised in the form of hearsay, but I do think that when you prevent a defendant from offering otherwise relevant evidence, that does impact due process, but it's raised as a hearsay question. So it would be a non-constitutional evaluation.
And you would agree that, I mean, in looking at the whole picture, it might be, the video might be very relevant to your defense, but one thing we have to evaluate is how strong was that defense to begin with. It may have been all you had to work with, but how strong it was to begin with, given everything else in the case, right?
We had a respected expert that said that it was a diminished capacity in her expert opinion.
Count the fact that he had already raised the same defense at his first trial and been unsuccessful there.
Structural error in that trial. He was not allowed to present the defense he wanted. He wasn't allowed to hire the counsel he wanted. He wasn't allowed to have any of the experts he wanted. He didn't have the money to hire this expert, so no.
I dissented in that case along with another member of our court, but you're right, that didn't carry the day.
So I don't think this is a question of harmless error if you look at it in the framework of a diminished capacity defense. If you're saying it's overwhelming that he shot her, then it would be harmless error. But that's not the question. The question is whether he had the capacity to form the intent at the time he pulled the trigger. And all this other evidence that we've talked about, the plan, that's about a plan to kill himself, not about to kill Gene Smith. That's the fact that he's suicidal, something that has happened to him throughout his history of his mental illness. He's been hospitalized for suicidal ideation over and over and over, multiple times. And so that's actually a symptom of a developing mental break. In the past, he got hospitalized rather than it resulting in a criminal case. But, yes.
Could you touch on this issue of whether a cautionary instruction would have been acceptable in this situation with regard to the hearsay issue?
I think at first you have to identify a hearsay, phrase that we were using it for. I can't look at that video and know what statement he's making I would want them to think is true. So I think the cautionary instruction in this scenario would be the standard one. It would be, there's being offered to present you evidence of his mental health, not to offer truth of what Mr. Krogmann or the agent is saying. It could be very simple. And we get those all the time in a variety of different contexts. The difference is that it's usually not the defendant trying to offer it about the defendant, because usually it's inculpatory rather than exculpatory. If there are no further questions on this, we would just ask that the,
I mean, I've watched much of the video, and you know, once you get past the shock of seeing him strapped in, and it reminded, you know, it's like these Al Qaeda people at Guantanamo or something. It projects this is menacing, and he's deranged. But as you go on, he is answering questions. He is tracking sequentially. Much of what he says seems to be consistent with what his girlfriend testified to. Can we decide ourselves that this wouldn't have helped him enough, that its exclusion was harmless error? Why not?
because it is the type of evidence that an expert needs to be testifying about. We did the best we could with our expert explaining what she saw in the video, what symptoms she saw in the video, but we couldn't show the video to show those symptoms and to distinguish her opinion from the state's expert who said that the video was completely irrelevant to his determination. And so I don't think a layperson can just look at it and make that determination. I think it is part of an expert analysis, which the expert did, but to be able to form her opinion, we have to be able to show the jury what she's forming it on. Thank you.
Your Honors, the defense misinterprets or misconstrues the state's argument relative to harmless error, and that is that everyone admits that he shot her. This is not a whodunit. But what we dispute is whether or not he had the specific intent to kill. And by virtue of his statements to Gene Smith at the time, it demonstrates a conscious effort to kill her. He told his employer he couldn't drive some equipment 3 hours away, but he could pick up a check from a customer and stay in the Manchester area. He brings a loaded weapon, and not just any weapon, a .44 Magnum, a very large and lethal gun. He gains access to her house. He asks for a hug. And when she turns around to pick up a cup of coffee, he has the gun pointed at her. She wouldn't have let him in if she'd known or seen that gun. And then he proceeds to shoot her the first time. She asks him to call 911. He said no. I didn't bring my phone in. I don't want to spend the rest of my life in jail. He shoots her a second time. This one is a defensive wound. She puts her arm up. She asks him again, please call 911. He says no. He shoots her a third time, and she collapses to the floor. Your Honors, if this doesn't demonstrate the intent to kill another person, I don't know what evidence the state could present to refute his mental health defense.
That would be a great closing argument, a great case to put forth. So why not let the dang video in? The video is pretty innocuous compared to what you just said. You can see our dilemma.
I understand what your dilemma is, and simply because some members of this court, if they were in the role or the shoes of the prosecutor, would have allowed it in, doesn't mean that the courts or these prosecutors' decision not to let that in was in any way demonstrates a miscarriage of justice for this defendant, such that it would...
Because you're fighting like crazy to keep it out, or not you, but the state, and then saying, don't worry about it, it was no biggie.
Well, Your Honor, I think that it's hindsight is 20/20, and when, again, I bring you back to what the district court had to determine at the time when the request for the admission of this exhibit was, and it was everything. They wanted everything. The court deemed it, here's it.
Counsel said she didn't know if it was an all or none. Was the 59 minutes hard? Was that a request by the defense that they wouldn't budge on?
The motion in limine ruling, the court said they've received from the defense Exhibit A, which is the first 59 minutes and 35 seconds of the interrogation video. The defense alerted the court and counsel they will seek to admit that portion, 59 minutes and 35 seconds. When you look at the testimony regarding the offer of proof after Agent Liao testified, counsel's comment was the whole thing has to come in. So when you are in the district court's position, it seems to be, based on this record, an all or nothing. Nothing the defendant said was, well, we'll pay parts of it or snippets of it or what we deem to be the most relevant relative to his mental health. Your Honors, I sound like a broken record, but the state submits that there is compelling evidence of the defendant's intent to kill Gene Smith, and that the Court of Appeals decision reversing his conviction should be reversed.
Thank you. The case of State versus Krogmann is hereby submitted, and court is adjourned for the afternoon.